Okay, are we ready?
Yeah, we're good. You're live.
Good afternoon. This is House Judiciary Committee. It's Tuesday, the 28th of March. It's a little after 1 o'clock. We're going to go ahead and get started and see the Vice Chair of JPR is here on the Safe Harbor Bill. Senate Bill 292. Lisa Jordan, watch out. There we go. All right. Mr. Vice Chair, I think there is a slight but somewhat significant difference between how the Senate passed this bill and how we passed the House bill. If you'd talk about that, we'd appreciate it.
Thank you, Mr. Chairman. Yes, thank you. This bill is exactly as the House has passed it, with one change on page 6, where it says in the original bill, the court shall dismiss the case if the court finds the child, and then lists when the court shall dismiss. We amended the bill to take out the case and only apply that section to the qualifying allegations. So previously I was in here asking that we take the House version of a bill. In this case, I was hoping we might be able to take the Senate version of the legislation.
So it wouldn't take the entire case, it would just take the charges, the relevant charges out.
Correct, the charges that qualify under the bill. So you can imagine a factual situation where someone commits a broad range of offenses. Some of them qualify, many of them do not. The phrase "the case" implies that the entire thing should be dismissed. That is not what we want. That was not the policy goal. The only things that should be dismissed are those that qualify under the legislation. So the remaining charges would stand.
All right. Questions for Mr. Vice Chair? For that, Vice Chair. Seeing none, we thank you very much.
Thank you, Mr. Chairman.
And that concludes the testimony on Senate Bill 292. Senator Carter, let's go ahead with 653. Is it in the same posture as the way that we passed it out of the House?
Yes, Mr. Chair, it's in the exact same posture as it passed out of the House.
All right. Are there in-depth and insightful questions that anyone wants to ask Senator Carter about this bill? What? You do? Okay. Oh, this was your bill. Oh. All right. Any further questions?
Would you entertain a motion?
No, not right now. Thank you very much, though.
Thank you.
Good effort. Thank you very much. Thanks very much, Senator Carter. That concludes testimony on 653. Senator Heddleman with two bills now, Senate Bill 789 and 615.
Yes, thank you.
789, is it in the same posture?
It is slightly different.
Okay, tell us the difference.
The difference is there was some concern by committee counsel that the Sexual Assault Evidence Kit and Funding Committee didn't have the authority to do certain things, and so the language was changed just to make it clear it was the Office of the Attorney General who will be making those changes. So it's just a slight tweak to the language, but in all other ways, it is the same.
Delegate Bartlett, does this raise any questions with you? These were your bills?
Nope, no questions raised.
All right, thank you. Any further questions for Senator Heddleman on 789? Seeing none, thank you very much. That concludes the testimony on Senate Bill 789. We'll go to Senate Bill 615. Second verse, same as first.
Same as first.
Yeah, is it the same
Exact
format?
posture, no, as the bill that you all passed, to my knowledge.
All right, does anybody have any insightful or deep questions to ask about Senate Bill 615? All right, seeing none, that concludes the testimony on Senate Bill 615. All right, Senator Lewis, Senate Bill 391. And this was cross-filed by whom? Oh, that's right, Delegate Simpson. All right, that's fine. And is it in the same posture?
Yes, it is.
All right, does anyone have any questions based on that? Oh, we're a little too fast, probably. Thank you very much for coming and visiting us today. Please remember to pick up your gift bag on the way out. And
May I just say a word of thanks to the committee? This is the third year in a row you all have passed the bill. The first 2 years I was the sponsor. I had to cross the street to get it passed on the other side. Finally, that's happened. Thank you for sticking with me on this really good bill, and in particular to the Vice Chair, who has helped me every step of the way. Thank you.
Now, does people, any really tough questions now? Or, okay, no? Thank you very much. That concludes the testimony for 391. We'll go to Senate Bill 129 because I don't see Senator McKay. Senate Bill 129, wait, Senator Kelly?
That's right. I see my Whitney. Hi.
Oh, dear.
I'm sorry, you're Whitney. No longer my Whitney.
Is the bill in the same posture as the way we voted it out in the House?
Absolutely.
Absolutely the same?
It is identical to the House version that passed unanimously, and it passed the Senate unanimously.
Are you sure?
100% sure, just 2 brackets.
Really?
Absolutely.
We're talking about the spousal defense bill,
That is
right?
correct. I would like to congratulate Delegate Crutchfield, who are working very hard on this, and I was
She's
happy
not even here to
I
hear me
know.
do this.
I was very happy to cross-file it for her and get it across the finish line, but it's all due to her hard work.
All right. Does anybody have any questions about Senate Bill 129? No.
Thank you.
Thank you very much. And that concludes the testimony on Senate Bill 129. Don't applaud all the senators. What is this? It's terrible. It's terrible. Oh. She's not really a senator? Oh, dear. Oh, dear. I don't know about that. Let's not go there. We are waiting in a holding pattern. They're both walking over? All right. So we will hear from Senator McCray. Is that in the same posture? McKay? Not Senator McCray, Senator McKay. And it's in the same. There's a little difference. Okay. All right. So we'll give them a moment to get in, and then there will be 2 full hearings for the chairman's bills on 859 and 686, so we're going to get to those next. So 1 moment, please. Court's indulgence. Senator McKay, did you actually just talk into your wrist and pretend that you were the chairman's? Oh, I think we need to get you out of here. Senate Bill 383, Senator McKay. Need to get you out of here right now. Senator McKay, I believe that this bill is slightly different than the way that we passed the House bill across. Is that correct?
That is correct.
Tell us the differences, please.
Well, the difference is that the House was correct in the manner in which it should be sent.
I'm sorry. Would you turn around and say that to the man behind you, please? There.
As the former detail of his security team. So if it was the pleasure to make this bill in the same posture as the House version, it would be appreciative.
Does anyone have any questions for this insightful and well thought out testimony from Senator McKay? Any questions? So we're going to conform it, the Senate bill, to the House bill. Okay. And seeing none, thank you very much.
Thank you. I'm going to head back to JPR, I think.
Wow. Okay. All right, Mr. Chairman, which one would you like to do first, 859 or 686?
Let's do the statute group of 686.
686 first. You have one person who's going to come up and testify with you? Okay, that's fine. This is a full hearing. We didn't pass House Bill 1, and so we're going to hear 686 because they've done the substantive work here, hear what the Senate has done. This will be like a regular hearing, I guess. Go right ahead, Mr. Chairman.
Thank you, Mr. Chairman, Mr. Vice Chair, distinguished members of the Judiciary Committee. Good to see you all. Senator Smith here to testify on behalf of Senate Bill 686. So just for some background, and I'll be brief, but for some background, in 2017, we passed a bill that essentially extended a window for people to bring forth these civil suits to basically the age of majority plus 20, so until they were 38, or alternatively, 3 years after there was a conviction for that underlying offense. So 3 years after that. There was some language, and this is where the controversy is, there was some language in that bill that called it, in uncodified language, they called it a statute of repose. And I'm sure you all have been well acquainted with the difference between a statute of repose and a statute of limitations, so we won't dive into that. What this bill does is create, and this is different than I think the initial posture of House Bill 1, is that it creates a back window that is not time barred. And so there are, the constitutional questions arise around that issue. So, Mr. Chairman, I'm going to just hit the highlights of the changes that we've made on the Senate side that you may not have heard during Chair Wilson's hearing here a couple weeks ago. So just walking through the bill, page 2, we go through, there's a definition of sexual abuse, but we also have taken out that unnatural and perverted sexual practices because we passed the bill that you have passed several years in a row, but we finally got it out of the Senate. If that clears both chambers, goes to the governor's desk, that'll be signed into law. This piece needs to be struck out of the code. So that's just kind of more of a technical fix. Moving down, you hear the look back window, the infinite look back window that we created. It may be filed at any time. That language is on page 3. And what we've done here that you may not be familiar with is we've created caps basically there's a public side and then there's a private side. So for private entities, this is all retroactively. For private entities, we've created caps for liability to $1.5 million. And for public entities, meaning under the Local Tort or the State Tort Claims Act or for the school boards, we've bumped up that liability to $890, and it is right now it's $400,000, and that's only retroactively and prospectively. So for the caps on the public side going forward, we've bumped up those caps to $890. Looking back, $890. Obviously, on the private side of the house, there are no caps for prospective claims. And so, obviously, what we're dealing with is in the past, not in the future. So, and we'll talk a little bit more about why that's important for the state tort claims, local tort claims, and the school boards. We have added in an element that says that you have to be alive at the time you file the claim. But if you pass away and the claim is still valid and still goes forward, so we made sure that you had to be alive when you're filing the claim. I've talked about the caps and the differences. There is an incident or occurrence language, which was subject to much debate in the Senate, but that's really just the language that, and Professor, correct me if I'm wrong, we plugged that right from the Tort Claims Act language. And so the courts are going to have to take those individual looks and, based on the facts of the case, make those decisions as to if it's one incident or if it's a continuing course of conduct. That's a fact-intensive inquiry that will happen under a judge. And then finally, I think the last interesting thing that you may not have been familiar with, we created somewhat of an interlocutory appeal process. Now, the chairman, in your daily work, you probably hear interlocutory appeal in the criminal sense. So, for instance, if there's a piece of evidence that is excluded for, let's say, a Fourth Amendment violation or an issue, you can have an interlocutory appeal, which is an evidentiary hearing on that piece of evidence. And if I'm not mistaken, Mr. Chairman, if you lose that interlocutory appeal, you may lose your case in chief. So we've created a similar mechanism. There are interlocutory appeals in the civil side of the House. We've created that mechanism for basically deciding the constitutional issue that arises under the whole scheme of the bill, if there is one. So you can decide whether there's a constitutional issue with creating this look back, decide that right away, then move forward with the case as normal. With that, there's one other small thing for the locals and the school boards. Their insurance, so bigger jurisdictions can run their own insurance, but smaller jurisdictions pool together for insurance. And because we've bumped up the tort claim liability, their insurance premium, there was a fear that their insurance premiums would rise. And so we've put in language to say that only for those child sex abuse claims does the cap rise up to the new $890,000 cap. And so with that, Mr. Chairman, those are the things that are substantially different from the initial posture of House Bill 1, and that's it.
Sure. Thank you. Kathy Hoke, professor at the University of Maryland, Carey School of Law. Mr. Chairman, Mr. Vice Chair, members of the committee, thanks for hearing from me very briefly today because Chairman Smith, as expected, did an excellent job going over the differences between the bill as crossed over to you as SB 686 and as presented to you initially as HB 1. I was here for the testimony on HB 1, as you're aware, and addressed the issue of the constitutionality of the retroactive application of the bill. I filed extensive written testimony on HB 1 and have resubmitted that here through the crossover of SB 686. I think the overarching principle being you have done an earnest and I think fair job at looking at this question, and the answer to whether it is constitutional to revive these time-barred claims is not clear under Maryland law. Your Attorney General says he will be glad to defend this statute, the constitutionality of it, if and when it gets challenged in court. And I agree with his assessment that we have very strong arguments on the constitutionality of this, and you have done your due diligence. You know all of the policy reasons. You heard a lot of that at the last hearing. So take comfort in knowing you've done your hard work on the constitutional question, and with clear conscience you can pass and should pass this bill. Thank you.
Rob, please.
Yes, thank you, Chairman. My name is Catherine Robb. I am the Executive Director of Child U.S. Advocacy. I have submitted written testimony. I have testified in person on Senate Bill 686 and House Bill number 1. I am here to answer any questions that may come up, and happy to do that. I do believe that I agree with the professor, and any issues have been addressed diligently by both committees, and I am here to support in any way I can. Thank you.
Are there questions for the panel? Delegate Munoz, then Cardin.
Thank you, Mr. Chair, and thank you to the sponsor for bringing this bill. I appreciate you summarizing the changes. I just wanted to just clarify, because I don't think I heard clearly. So for public institutions, the cap moving forward is $890,000, and for private, it's 1.5. Is that correct?
So yes, so what we've done is for the local tort claims, the state tort claims, and the school boards, we've raised the cap from 400,000 to 890. And that's for prospective claims and for the retroactive claims. For the private entities, only retroactively, it's capped at $1.5 million. In the future, there's obviously no cap.
And so is that the retroactive and prospective, is that a change from what's currently in the law or what was in HB 1?
Well, it's currently in the law. You can't go retroactive to get these claims. So past the, being 38 or 3 years past the conviction from the underlying. So that's a change. And moving forward for the public entities, we're raising the cap. We're more than doubling the cap of liability going forward.
Okay, and there's never been a cap going forward for private entities?
No, there isn't.
There never has been?
Never has been.
Okay, and so what was the cap for the past previously? If it's the 3
For
years
public or for public?
private?
For private, no cap.
There has never been one. Okay.
And remember, you're just time barred, so we can't go back. We can't go retroactively under the current law, and so there's no cap on that, obviously, because there's zero possibility of recovery right now.
And did you guys consider making both private and public caps and retroactive prospective caps the same?
That was a subject of discussion, but I remember on the floor this came up, and it just talks about the whole notion of, sovereign immunity. And so I gave the example of if you were at the University of Maryland and you fell down a manhole cover or down in the sewer, your recovery would be capped at right now $400,000. But if you went up the street in the same incident, same set of facts, and you fell down that same hole at Johns Hopkins University, there's no cap. And there's a policy reason for sovereign immunity, because the government provides services and is critical to ensuring our way of life. And so that's a policy decision that we revisit from time to time to expose the sovereign to more liability. We did that at police reform. In police reform, we bumped up the caps to 890. That was a policy decision that this body made after much deliberation and debate.
No, I do vaguely remember learning that at Cary Law, but I really appreciate the
There you go.
refresher. Thank you so much.
Thank you, Mr. Chairman. Thank you very much for coming in and talking on this important piece of legislation. First of all, just going back to Delegate Munoz's question, the cap is for any liability, not just for sexual abuse liability. Is that correct? We're increasing the cap for...
No, we've done it for sexual abuse only.
It's only for sexual abuse.
That's right.
For child sexual abuse.
For child sexual abuse. So the cap for other types of claims would still be the...
For other torts and claims, still at 400,000.
400,000. So we're going to have
apart from police, which is 890 as well.
Okay. So my question is about the interlocutory appeals, which is a great idea, but wouldn't once somebody tests it out, I guess this is really for
it only needs to happen once. Okay.
It only needs to happen
because then the constitutional issue is settled and we can all go on with our lives.
So right. So it's just so we're doing this for basically that first test case, and then it'll all be done.
It's to expedite the process, and I think that would balance people's concerns with people creating cottage industries from this bill. People going out and getting clients and making money off of essentially victims and survivors of child sex abuse. So this settles that issue. This also heads off that issue of people suing and then trying to settle, sue, settle, sue, settle, sue, settle. You cut that off right away. We answer the question. We can all move along.
Great. Thank you.
Vice Chair.
Thank you, Mr. Chair. So I also have questions about the cap, and I guess the private retroactive cap in particular. I guess at first blush, I think I thought I understood the sort of policy and political context around why that might make sense until I started reading that the church is likely to declare bankruptcy immediately upon change in law, as they've done elsewhere, and suddenly I'm wondering about the private cap. I guess surely that framework has been put in front of you.
So I'll let you explain, because you've got more of an insight to the national scene and what happened even in Delaware. But what I'll say is that with a bill like this, you've got to balance equities. And there are several institutions in play here, private schools, other private entities that render valuable services to society. And so this is not a very easy discussion to have, especially with regard to child sex abuse. And so it was our attempt to balance those equities and say, look, we're going to create this infinite look-back window. We're going to cap this liability. And it's hard to talk about caps to any survivor. I think if we do this, we'll be the only state in the nation that actually has caps. But we're also one of the only, I don't know how many other states have created infinite lookbacks. Most of the lookbacks, it's a kind of a pattern, right, throughout the nation. Some have created 2-year lookbacks, 5-year, 10-year, whatever. So in balancing these equities, we've created an infinite lookback. We've exposed private entities to, for forever. And so it was an attempt to strike some semblance of balance, and it's a very difficult discussion to have out loud, especially with regard to this issue. So that's where we were going with it.
Yeah, and I mean, I'd like to call on Delegate Munoz to answer the question. Oh, wait, I don't have that power here, do I? No, I want to say you are right, and this is, honing in on the issue that a cap disadvantages the plaintiffs, for sure, whether they're proceeding in litigation or it's going to ultimately end in settlement. The survivor community recognizes what Chairman Smith just said, and that this bill contains within it a lot of compromises, and I think understanding that getting a open time, and a permanent look back, if you will, allows survivors who are still managing to accept and come to terms and decide whether they want to come forward with claims, don't have a 2-year, 24-month time to do that, balanced against, okay, then we will have caps for the private entities for the look-back one. So I appreciate your earnestness in looking at that because it does disadvantage plaintiffs. And then just tiny bit on the bankruptcy issue. It, again, disadvantages plaintiffs in that context as well. Another reason we have a difference between public and private entities is public entities can't declare bankruptcy. We do know in some cases people will get pennies on the dollar because of, I think, an inequitable bankruptcy system of Chapter 11. But again, getting this bill crossed over here the way it is was a Herculean and effort that I think we're really proud of. And so thanks for acknowledging the sacrifice that the plaintiffs, the survivors who will potentially become plaintiffs have made here. Really appreciate it.
And if I could just add to this conversation briefly, at Child US Advocacy and at Child USA, we looked at 218,000 cases across the country in child sexual abuse. And so the number of 1.5 really reflects what we see in terms, at least, of settlements. It's a little bit higher than settlements, significantly less than the verdicts. So I know that we did feel quite comfortable also after sharing this data, that was a reasonable number, although Maryland will be the only state with caps. And then if I could just add that in terms of Chapter 11 bankruptcy, just a couple of things that I think are important to note, that one, it's a voluntary filing under Chapter 11. Two, there is no requirement under the code to be insolvent, and we have seen that all of these organizations, including many Catholic dioceses across the country, are not in fact insolvent. And the final, probably more important piece is that we also know that across the country in all of these dioceses that services continue. No services has been terminated because of a filing of Chapter 11 based on a child sexual abuse claim. So I hope that helps your understanding.
Delegate Bartlett.
Thank you, Mr. Chair. I just have a question since we are talking about bankruptcy. I'm not sure who's the best person to answer this. Ms. Robb was kind of getting there, but I'm not sure. So what happens if there is a pending claim and if an entity files bankruptcy? I just don't remember. Will that pending claim still fall, could they still be a
Debtor,
creditor?
creditor.
Would they still be a creditor?
Yeah. So basically what happens if you have a pending case and an entity that you filed suit against files for bankruptcy, the case is stayed in the regular court and becomes a part of the bankruptcy proceeding. I'm sure Catherine can speak to this, but most of those cases end up settling because otherwise you're litigating them through the bankruptcy system, which is not particularly effective for tort claims. So they do tend to be then part of the big bankruptcy transaction.
Okay. Would they fall within the would that retroactively bump in the claim amount? Would that benefit them if they have a pending claim, since this is a retroactive bill, or is the retroactivity merely the statute of limitations?
So, and I'm not aware of any pending claims that are in, so the cases that we're reviving here are time-barred claims, and so people can't bring those cases. I'm not aware of any of those cases pending, and that's what the cap would apply to, the new ones that come in. Does that answer your question?
It answers my question, but just in case there are some, would it fall?
Would the cap fall on them? Yes, because their cases would otherwise be dismissed because when you pass this through the full House, which I expect you to do this week, then their claims will be revived and then they won't be dismissed, but they will be subject to the cap.
No, I mean, if there are any pending claims,
yes,
would those pending claims be receive the benefit of the cap, or would those pending claims? I'm doing a hypothetical.
It's a fascinating legal time argument. It's a weird time jump argument.
So if there's a claim that's sitting right now that would be time barred, right? So a motion to dismiss would probably easily, make it go away. You pass this bill, this is now law effective, I guess, October 1st, right? And so the case is waiting for that to happen. It doesn't get dismissed. All parts of this bill will now apply to that claim.
Great.
Because it otherwise is a non-existent claim, if you will. It's a legal falsity at this point.
Yeah. Yeah. Okay, good. That's what I was hoping, because I could imagine that if someone has been following the news and hearing that this bill is passing and progressing, then, you know, they may have been time barred before, but I would think that they could have, you know, maybe start working on their.
So lawyers are, I'm sure, working on those cases, but they probably haven't filed them.
Okay.
Yeah.
Okay. Thank you for the discussion.
Of course. Thank you.
If I could just add one point about that and just addressing specifically right now Boy Scouts of America, on those bankruptcy claims, they are looking at the statute of limitation in each state as a measure of potential damages. So this bill would clearly help so many survivors in the Boy Scouts of America.
Any further questions on this? Delegate Williams.
Yes. Hi. Just to continue the bankruptcy conversation, you mentioned that in some cases when the bankruptcy is filed, a lot of times they get settled. Are we aware of kind of roughly what those dollar amounts are, or because they're settled, we don't have an understanding of roughly what those payouts are in those cases?
Yeah, Catherine has that data. Oh, yeah. Catherine has that data.
Okay.
Did you hear the question, Catherine?
I did, thank you. So again, we looked at over 218,000 cases across the country. They were Boy Scouts and other types of cases as well. And the average settlement was about 1.3, almost 1.4 million dollars. The average verdict was about close to 3.4 million. The verdicts are always higher. But again, I really would like to point out that we are seeing in bankruptcy these unsecured creditors, which is what these victims become, right? That they are getting higher settlements amounts because the courts are looking to the statute of limitations within the jurisdiction where they were harmed. So that's why this piece of legislation is also so important for those survivors.
Got it. And I have one other question, Mr. Chair.
Go on.
Okay. Chair Smith, you had mentioned that, and I see the provision here in the Senate bill about if the person is deceased, then obviously the estate cannot pursue forward with the claim. But I just want to make sure I'm clear on that. So if they're deceased, then the estate of that deceased person cannot move forward with the claim against whatever entity that might have been housed for the abuse.
Two things. One,
Okay.
it only applies to revived claims. Two,
Okay.
if you were alive but then passed away,
Right.
your estate can still carry on.
They can still move forward. Okay, thank you. I just wanted to make sure I was clear on that. Thank you.
Any further questions on this bill? Seeing none, we thank you all very much.
Thank
and
you.
that'll
Thank you very much.
conclude the testimony on Senate Bill 686. We're going to go now to Senate Bill 859, again with the chairman. And he's going to have with him Michelle Siri and Robin Elliott, who are going to come to the table. Nobody there virtually. And Mr. Chairman, go ahead.
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. Senator Smith here again to present Senate Bill 859, which is substantially similar to our distinguished colleague here, Delegate Williams, who presented this bill a few weeks ago. There were just 6 amendments that we tacked on in the Senate, so I'll just review those, and then we can stand for questions. But I think you've had the bill hearing, and it's basically exactly the same, separate apart from these amendments. So the first substantive amendment creates an exception to the prohibition in the bill against a court granting an order for the electronic surveillance to investigate facts related to legally protected health care, where the acts forming the base of that claim were in Maryland and legal in Maryland, were not a crime, or would constitute a crime here in Maryland. Amendment 3 clarifies language in the bill relating to the prohibition on health occupations boards taking disciplinary action. Remember, this bill prevents the if you're licensed from being from our health occupations board from taking disciplinary action because of something that happened that was legal here in Maryland but was not legal in another state. Amendment number 4 clarifies the prohibition on insurers taking adverse actions against practitioners who make referral to legally protected health care and to another state that does not protect or it is not as friendly as Maryland. And then amendment number 5 clarifies that medical professional liability insurers required annual submission rates to the Maryland Insurance Commissioner or administration. It does not qualify, that requirement does not qualify as an adverse action. And then the last amendment just changes the effective date. It pushes it out to June 2023. Otherwise, the bill is in the exact same posture as Delegate Williams' bill. Sure.
Yes, good afternoon. For the record, my name is Michelle Seary, Executive Director of the Women's Law Center of Maryland. I'm here still in favor of Senate Bill 859. As the chair just said, the changes have really been technical and clarifying in nature. But since we have been here and testified the last time, I did want to add that one more state, New Mexico, has also passed a shielding law, and Washington State has passed it through their House and is waiting to pass it through their Senate. This is no longer hypothetical. We are seeing the lawsuits happen. There is a lawsuit that's currently pending, an SB 8-style lawsuit in Texas against the friends of an ex-spouse, a former spouse, for helping to provide abortion care to them. That is not happening in Maryland, but it's just a matter of time. And so we are here in favor and happy to answer any and all questions that you may have.
Thank you, Mr. Chair. Robin Ellie, I'm here today on behalf of Planned Parenthood of Maryland in full support of the bill. I just wanted to add that I had a conversation with a provider from a state in which abortion is banned, who was very nervous about referring that person to Maryland specifically because Maryland doesn't yet have a shielding law. So we are really very thankful and appreciative of this committee hearing this bill and really paying close attention to this issue. Thank you.
We're joined by people and members from the Health and Government Operations Committee who are behind me and on the horseshoe. Does anyone have any questions for this panel? Delegate Cardin.
Quick thank you for bringing this very important bill. I look forward to voting for it. Just amendment number 4 you talked about, I think it's line 17 of page, I'm looking at the reprint, page 9 of 10. I think that's the amendment. I'm just trying to make sure I understand so that because oftentimes we get questions, and I just want to make sure we understand what we're requiring these insurers to do. I don't know, maybe, Michelle, you can answer that.
Sure. So this is making sure that we're distinguishing between the provision of care that a provider might be giving and then the folks who are referring, such as the rape crisis counselor, the any other kind of social worker, those types of people who might be referring cases, because they should not be held to the standard of care. That's really why.
Okay.
We just wanted to make sure that we were separating that.
Got it. Thank you.
Delegate Boucher.
Thank you, Chairman Smith, for being here. Does the state of Maryland potentially run the risk of reprisatory action against them from another state that does not respect this law, like in extraditing criminals and stuff like that? Do we run that risk?
Of kind of a reprisal from another state? I mean, so the bill does speak to, and I'll defer to Michelle on this, but for the extradition, there are permissive extraditions and then there are mandatory extraditions, and this bill only deals with permissive extraditions.
All right. So we don't have to worry about anything like that, blowback, so to speak, from a state that does not respect the way we are looking at this.
No, and one could argue this, it's almost like the premise of the bill is to make sure that there is no kind of professional, criminal, or civil blowback to people operating in Maryland.
I just want to make sure we don't run afoul of agreements of other states with this.
No, this would honor, again, the distinction between permissive, and I'll let Michelle, you can dive into permissive and mandatory. I think this bill only deals with the permissive side of the House.
Yeah, you're absolutely correct. It's only dealing with the permissive. So it's not going to violate anything that happens in that state. It's only going to deal with criminal actions that allegedly occur here.
Thank you very much.
Further questions? No? Okay, that concludes the testimony for House Bill 859. That concludes the bill testimony today for Tuesday, the 28th of March, 2023. We all want to, again, now in committee, welcome Delegate Simmons back to the committee again. Welcome him back. We will have bill hearings tomorrow. We are expecting 71 witnesses tomorrow, 71 witnesses tomorrow here. We will have a voting session after bill hearings tomorrow, so you should expect a longer day tomorrow. Thank you all very much. We're adjourned.